is calling 2025 CR 003791, State versus Andre Crawford. Could I have parties announced for the record, please?
Ethan will be for Mr. Crawford.
And are you Mr. Crawford?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Crawford, did you review the document entitled Application for Deferred Adjudication with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Crawford, did you review court admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places? You're charged with theft of property, $2,500 to $30,000 as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Crawford, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, sir.
Did you understand by entering this plea, if you are not a U.S. citizen, you could be deported, denied naturalization, and not allowed re-entry into the country? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, there's a $0 fine. State recommends deferred adjudication. There's to be restitution in the amount of $3,746.99 to target. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Hmm.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 5 years. There'll be a TAP evaluation, 200 hours of community service restitution, no contact with target, and Michaela, Makhayla, Pean, Pean, a mental health evaluation, follow recommendations, the anti-theft course, and healthy relationships course. Did you understand those were recommendations by the state and the court does not have to follow those recommendations? Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Crawford officially changes his plea to no contest, a move that protects him from civil lawsuits while still exposing him to criminal punishment. It's clever lawyering, but it also raises eyebrows. Is this about accountability or just avoiding financial fallout? For the audience, this is the first big turning point, where the legal chess game begins. Would you take a plea like this to dodge civil damages or risk it all in a jury trial?
I believe the paperwork says no contest.
All right. Do you understand what a no contest plea is? You're not saying that you're guilty in layman's terms. You're not saying you're guilty. You're not saying you're not guilty. You're just not fighting the charges against you. However, I can still find there's sufficient evidence to find you guilty. But because you've applied for deferred adjudication, if I follow your agreement, I'm not going to find you guilty. I'm going to defer finding of guilt. Do you understand?
Yes, ma'am.
Normally, people will enter no contest pleas if there is any type of restitution is owed, because people can always sue you civilly. So sometimes your attorney is trying to protect you civilly. So by pleading no contest, if there is a civil suit involved, whoever wants to sue you out of something that arose from this incident, they would have to go to a civil court and prove that. Do you understand?
Yes, ma'am.
So are you pleading guilty or no contest?
No contest.
All right, state any evidence to support the defendant's plea.
State offer states one in attachment.
No objection, Judge.
All right, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, so here's my question. I see that they say that he stole Apple iPad Air, which I understand. But in one place, on June 24th, 2024, they say he stole an Apple iPad and it costs, I'm sorry, an Apple iPad Air, and it costs $799. Then they said he stole another Apple iPad Air and it costs $1,200.
This is our based on like the storage space that the iPads have, and so like if it's like a 60 gigabyte, then that would be cheaper than a 120 gigabyte storage. So
So
it's
the,
attached, I think I can place to you, but
sure. So the Apple iPads have different
they have different
storage.
storage.
Oh, okay.
Yeah, so I did attach this, and so like
Okay.
here you'll see the
Oh,
storage on it.
Thank you. That explains it.
Guess otherwise you'd want to go shopping.
I'm sorry.
I guess otherwise you'd want to go shopping for the cheaper iPad with the same storage.
Oh, I have no idea. I don't do Apple. No offense to Apple. I
Yeah.
just, my thing is, I'm not trying to learn anything new, computer related. I still on my phone, which is, I think, a 6, and they're already on 29.
This exchange about stolen iPads may sound almost comical, debating storage space and price tags, but legally, it matters. The exact value of stolen property often determines the severity of charges. Here, the difference between $799 and $1,200 could shift the stakes. Notice how the judge jokes about not wanting to learn Apple products. Even in tense hearings, humor sneaks in. But ask yourself, should a case hinge this much on product pricing, or should theft be judged the same no matter the brand?
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding you guilt as you've applied for deferred adjudication. So these are some questions I have. Number 1, why is there a request for mental health evaluation?
So the recommendations that are below the line are based on my analysis of a different case. So it's a global offer where he's not going to be on supervision for the misdemeanor case, but that's where the conditions are.
All right, so that's the mental health evaluation is based upon the misdemeanor case?
Yeah, the mental health evaluation, the healthy relationships, and then the no contact order with the named individual.
All right, and who is the named individual? What's the relationship to the defendant? Okay. All right, so then my next question for you, Mr. Crawford, when are you going to have this $3,746.99?
I don't know exactly, but less than a year for sure, or less than like
When are you going to be able to make a down payment towards this?
as soon as possible.
What does that mean, though?
I get paid on next Tuesday.
All right, what do you do?
I work at BJ's restaurant.
All right, so how much you're going to be able to pay towards this?
I can put down 300.
300?
Yes, ma'am.
All right, when will you be able to put down 500?
500. I don't know the exact date, but I have it on me.
Oh, do you want to look at a phone now?
I have my phone on me.
Okay, oh yeah, you can look at it.
Crawford owes nearly $3,800, and the judge presses him for exact payment dates. You can feel the shift from abstract legal talk to real financial consequences. For many defendants, restitution is heavier than the sentence itself. Imagine working at a restaurant, making modest pay, and owing thousands to a corporation like Target. Should ability to pay influence sentencing, or does justice mean full repayment no matter the hardship?
On the 16th of October.
October 16th.
Yes, ma'am.
All right, so this is what we're gonna do. I'm going to sentence you. Let's see. Norma?
Yes.
Are you able to recall this back on October 21st?
Yes.
All right, so you're gonna be sentenced on October 21st. Ms. Abrams? He's gonna have $500. Should he make that out to someone other than, all right. So he's gonna bring in $500 towards Target. And then when you come back on October 21st, you need to be able to tell me how much you'll be able to pay per month towards this restitution. All right? So we're gonna recall you back on October 12th.
Did you put October 12th or?
I'm sorry, October 25th, 21st. Yeah, the days are just all over my head today. So we're bringing you back on October 21st. On October 21st, you're gonna need to bring $500. Do it in the form of cashier's check or money order. What do you need? All right, so either a cashier's check or a money order.
Yes, sir.
And usually the money orders and cashier's check, they usually cost the same. So you can get the cashier's check or money order from a bank, or either you can get the money order from, HEB or some of those other stores. All right, so we will see you back then. Once you get the reset form, and you sign it, you're excused, okay?
Yes, sir.
All right, thank you.
And that's the ruling. Crawford will return with a $500 payment, his deferred adjudication hinging on whether he keeps up with restitution. No prison yet, but a single missed payment could unravel everything. This case shows how justice isn't just about guilt or innocence, it's about negotiation, finances, and second chances. What do you think? Is deferred adjudication fair mercy or a revolving door for repeat offenders? If you found this breakdown eye-opening, hit like, drop your opinion in the comments, and subscribe for more true courtroom drama.